Se confía en que los policías cumplan la ley, pero ¿qué ocurre cuando la infringen? He aquí 4 veces en que los policías reaccionaron ante sus condenas a cadena perpetua.
All right, the verdict seemed to be in proper order. This is in the District Court of Oklahoma County, State of Oklahoma, the State of Oklahoma versus Daniel K. Holtzclaw, case number CF 2014-5869. Verdict, count 1, sexual battery. We, the jury, impaneled and sworn in the above entitled cause, do upon our oaths find as follows. Defendant is guilty of the crime of sexual battery and set punishment at 8 years.
Este es el exoficial Daniel Holtzclaw, del Departamento de Policía de Oklahoma. El 11 de diciembre de 2015, el señor Holtzclaw se presentó en el juicio para escuchar el veredicto sobre los cargos a los que se enfrentaba en relación con 13 violaciones. El señor Holtzclaw tenía 29 años en el momento de la vista. Su padre, Eric Holtzclaw, ha servido al Departamento de Policía de Enid como oficial de policía también. El señor Daniel Holtzclaw tenía aspiraciones de convertirse en jugador de fútbol americano. Sin embargo, después de no tener éxito en eso, decidió unirse al Departamento de Policía de Oklahoma. Desde su ingreso, no ha tenido un buen perfil como oficial de policía. Esté atento a cómo se desarrolla la vista cuando el juez anuncie los veredictos de los cargos presentados contra él.
All right, the verdict seemed to be in proper order. This is in the District Court of Oklahoma County, State of Oklahoma, the State of Oklahoma versus Daniel K. Holtzclaw, case number CF 2014-5869. Verdict, count 1, sexual battery. We, the jury, impaneled and sworn in the above entitled cause, do upon our oaths find as follows. Defendant is guilty of the crime of sexual battery and set punishment at 8 years. Count 2, procuring lewd exhibition. Not guilty of the crime of procuring lewd exhibition. Count 3, burglary in the first degree. Defendant is not guilty of the crime of burglary in the first degree, nor lesser included. Count 4, procuring lewd exhibition. Defendant is guilty of the crime of procuring lewd exhibition, and punishment is set at 5 years. Count 5, procuring lewd exhibition. Defendant is guilty of the crime of procuring lewd exhibition, and punishment is set at 5 years. Count 6, defendant is not guilty of the crime of stalking. Count 7, defendant is not guilty of the crime of sexual battery. Count 8, defendant is guilty of the crime of forcible oral sodomy, and punishment is set at 20 years. Count 9, rape in the first degree. Defendant is not guilty of the crime of rape in the first degree. Count 10, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy, and punishment is set at 16 years. Count 11, rape in the first degree. Defendant is guilty of the crime of rape in the first degree, and punishment is set at 30 years. Count 12, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 13, sexual battery. Defendant is guilty of the crime of sexual battery, and punishment is set at 8 years. Count 14, sexual battery. Defendant is guilty of the crime of sexual battery, and punishment is set at 8 years. Count 15, procuring lewd exhibition. Defendant is guilty of the crime of procuring lewd exhibition, and punishment is set at 5 years. Count 16, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy, and punishment is set at 16 years. Count 17, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 18, procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Count 19, procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Count 20, rape in the first degree. Defendant is not guilty of the crime of rape in the first degree. Count 21, sexual battery. Defendant is not guilty of the crime of sexual battery. Count 22, sexual battery. Defendant is not guilty of the crime of sexual battery. Count 23, sexual battery. Defendant is not guilty of the crime of sexual battery. Count 24, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 25, rape in the second degree by instrumentation. Defendant is not guilty of the crime of rape in the second degree. Count 26, indecent exposure. Defendant is not guilty of the crime of indecent exposure. Count 27, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy, and punishment is set at 16 years. Count 28, rape in the first degree. Defendant is guilty of the crime of rape in the first degree, and punishment is set at 30 years. Count 29, rape in the first degree. Defendant is guilty of the crime of rape in the first degree, and punishment is set at 30 years. Count 30, sexual battery. Defendant is guilty of the crime of sexual battery, and punishment is set at 8 years. Count 31, rape in the second degree by instrumentation. Defendant is guilty of the crime of rape in the second degree, and punishment is set at 12 years. Count 32, rape in the first degree. Defendant is guilty of the crime of rape in the first degree, and punishment is set at 30 years. Count 33, sexual battery. Defendant is guilty of the crime of sexual battery, and punishment is set at 8 years. Count 34, sexual battery. Defendant is guilty of the crime of sexual battery, and punishment is set at 8 years. Count 35, defendant procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Count 36, procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Let me ask the jury, is this your verdict, so say you all? Yes. All right. Counsel, would you like to examine the verdict forms?
Not to say no.
No, Your Honor. All right. Mr. Holtzclaw, you and your attorneys just come forward. Mr. Holtzclaw, this jury finds you guilty of the various counts. You will be remanded to the custody of the Oklahoma County Sheriff for formal sentencing set January 21st, 2016 at 10 o'clock a.m.
Your Honor, I'd ask to poll the jury.
All right, if you have a seat.
El señor Holtzclaw lloraba tras escuchar el veredicto en su contra. El juez anunció 263 años de prisión y le declaró culpable de 18 cargos. El veredicto se anunció después de 1 año y medio. El señor Holtzclaw, durante su época de oficial, solía realizar comprobaciones innecesarias de antecedentes de ciudadanas con órdenes de detención pendientes o antecedentes penales, y solía aprovecharse de ellas como víctimas. También fue declarado culpable de agredir a numerosas mujeres, generalmente de clase baja. Los abogados y procuradores de las víctimas se mostraron satisfechos con el veredicto y deseaban para él una condena que le mantuviera en la cárcel de por vida. Si crees que este ha sido el único policías idiotas que ha reaccionado ante su cadena perpetua, espera a ver el siguiente caso.
I'm still troubled by the fact that you did not address Mr. Howard.
I can address it. No, that's all right, Your Honor.
No, it's not all right.
I don't need to.
You do need it.
Right.
You say you can't move on. I'm telling you, you need to move on.
Este es el exoficial Michael Amiot, del Departamento de Policía de Euclid. El 31 de marzo de 2023, el señor Amiot acudió al juicio para escuchar el veredicto sobre un caso de 2017 en el que fue acusado de agresión e interferencia con los derechos civiles durante una parada de tráfico. Tras la parada de tráfico, Amiot fue suspendido durante 45 días, tras lo cual la alcaldesa de Euclid, Kirsten Holzheimer Gale, lo despidió del cuerpo de policía. Sin embargo, un árbitro independiente lo readmitió en 2018. En agosto de 2019, Amiot fue detenido y acusado en el Tribunal Municipal de Euclid tras una nueva investigación sobre el incidente. fue declarado culpable de agresión e interferencia con los derechos civiles en julio de 2022 y posteriormente fue condenado a 1 año de control comunitario, sin denuncia. El 31 de marzo de 2023, tras casi 8 meses de ser declarado culpable, el señor Amiot vuelve al juicio para su sentencia. Mira cómo reacciona cuando se anuncia el veredicto.
Your comments with respect to the things the court is required to take a look at in imposing a sentence. Based upon the evidence presented and the pre-sentence investigation, the court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000, and will require you to pay the court costs. In addition, the court will suspend the sentence of 90 days, place you on non-reporting community control for a period of 1 year. If you violate during that 1 year, then the court will retain the ability to impose the sentence. Anything on behalf of the state?
No, Your Honor.
On behalf of Ms. Damia?
Just what count is this in? Or electing the sentence?
What count? While Mr. Hubbard's rights were violated, and the officer, as an officer, he used his authority to do that. However, given the length of time involved here, the court will use the assault as opposed to the violation of civil rights. Not saying they weren't violated, but given the length of time, the court will use the assault charge. Anything else?
No, thank you, Your Honor.
That's all. Good luck to you, sir.
Thank you.
I'm still troubled by the fact that you did not address Mr. Howard.
I can address it. No, that's all right, Your Honor.
No, it's not all right.
I don't need it.
You do need it.
Right.
You say you can't move on. I'm telling you, you need to move on. Not easy. Life is not easy. But as long as you let that handicap you, he has control. As long as it handicaps you, he has control. You make that decision, sir. Do you want him controlling, or this situation to control you?
No.
You need to think about that. That's all.
All rise. Court is now adjourned.
You all do what you want to do.
El juez impuso a Amiot 1 año de control comunitario no comunicable con una multa de $1,000. Esta decisión se produjo después de que el juez anunciara inicialmente una pena de 90 días, que luego fue suspendida. El juez también especificó que el castigo solo se aplicaba al cargo de agresión. Si crees que esto es lo máximo que un policías idiotas puede reaccionar a su condena de por vida, entonces probablemente no estás al tanto del siguiente caso.
Well, it's very difficult because I can't go into a lot of the evidence because obviously that would require, that's not part of what an urgent interview is, okay? This interview is just about trying to find her. Because
Sure.
she's been missing for a while now.
I'm sat in handcuffs and you're asking me what I know her. So you must have something to say that I know her.
Well, as I said, you've been arrested on suspicion of kidnap, and we believe that you've been involved in her disappearance and taking her away from her family.
Este es el exoficial Wayne Couzens, del Departamento de Policía Metropolitana. El 9 de marzo de 2021, la policía se puso en contacto con el señor Couzens para investigar el caso de una señora desaparecida, llamada Sarah Everard. El 3 de marzo de 2021, la señora Everard volvía a casa caminando desde la casa de su amiga, en Londres, Inglaterra. Sin embargo, ella no sabía que estaba siendo seguida por un vehículo blanco. Ese mismo vehículo blanco fue alquilado por el señor Couzens en un concesionario de Dover, Kent. El señor Couzens se acercó a la señora Everard y supuestamente la arrestó por infringir los protocolos COVID-19. La llevó al coche blanco que había alquilado y condujo hacia Kent. Vea lo que averigua la policía cuando interroga sobre el asunto.
So we're here to talk to you about Sarah. I'm going to show you a picture. Do you know Sarah?
I don't know.
Okay. Sarah went missing. I'll show you some pictures of her on the day.
Okay.
Sarah went missing on Wednesday, and her parents obviously and her family are really worried about that now. The inquiry that's been conducted so far has led us to come and speak to you about it and to see what you know about Sarah, okay? So, would you like to, do you know where Sarah is?
No.
Right, okay. Do you know anything about what happened to her?
I know that she went missing up in London somewhere. About a week ago or so. Just from what I got on the news.
Okay. Have you ever personally met her?
No, not personally, man.
Have you had any interactions with her at all?
No, why would I have personal interactions with her?
Well, it's very difficult because I can't go into a lot of the evidence because obviously that would require, that's not part of what an urgent interview is, okay? This interview is just about trying to find her. Because
Sure.
she's been missing for a while now.
I'm sat in handcuffs and you're asking me what I know her. So you must have something to say that I know her.
Well, as I said, you've been arrested on suspicion of kidnap, and we believe that you've been involved in her disappearance and taking her away from her family.
Okay.
So we are trying to find her. Obviously, everybody is very worried about her. She's got, parents. She's got, she's got siblings. She's got a boyfriend. There's a lot of people that care about her.
Sure,
You've seen
sure.
her on the news. The number of people that are reaching out about her.
Sure.
Out there looking for her every day, and she's missing. And our job, our primary job here, is to find her and to try and find her safe and well.
Okay.
Now, we believe that you know something about where she is, and that's why we're here, to look for her and to try and find her. And that's why we're talking to you now, is to try and get you to have a good think about it and tell us anything you can about whether or not you're to find her.
Okay. Well, I am in financial and I've been lent on by I don't know who they are. They're a group, a gang, whatever, and they told me, right, I need to go and pick up girls and give them to them. So I said, not happening, and it then came through that they're going to harm my family, take them away, and they'll use them instead. At that point I had no option to try and find somebody. So I don't, there's a couple of names. I was told a place to take her. That's it. That is all I know. And to this group of people.
Tell me about them. I need to find them. Tell me everything you know that I
Okay.
think that you'll help me.
There
find.
was a white Sprinter van. They it was between sort of Lenham, Maidstone area. that I dropped her off. I still don't know. I don't know. They just I just parked my car up, and then the van come up behind me, flashed me. They all jumped out, and then they took this girl. They said, "You've done good," and I don't know whether my family's going to be alright still. But they threatened to take my family away from me. So at that point, I'm doing what I can to protect my family. That's it. So all I know is that it was a roundabout. We could drive there now. I could show you. But roughly, I don't know Lenham Maidstone area at all.
If we did it on Google, if we did it on Google Maps, like Google Earth, if we drove it, would you be able to do it?
I drove from Ashford to Maidstone.
Yeah. Okay. Yeah.
There's a roundabout that breaks up, I guess. So this is the first big roundabout that you come to. And you would carry straight over to Maidstone, but instead I went round that roundabout and back up another road. And at that point, I was flashed and pulled over. You guys got out, opened my door, opened that door, pushed me out against the front of the car, took the girl, drove off. That's it. They said, "We'll be in touch." So I'm here, I'm off work with stress because I'm here to protect my family. I want to be here 24/7 for my family. They come from my family. I've got nothing myself. I've got no choice.
I'll go back through the route with you in a minute, alright? But how do they contact you? How did you contact them?
I tried to take over one of their call girls and rip her off. So she's told them, and they've got me. So
How do they? No, but honest, how do they contact you? How is it they've been in contact with you to make these threats?
they just tell me, be here. So Hotel Burston down in Folkestone, got to be here. Okay, so I turned up. But I've got no mobile number, and they have got my mobile number.
They haven't.
They're obviously outside watching, following. I just, honestly,
How are they telling you to be there? And be there? How is it they're giving those directions?
yeah, they'll come outside. So they'll be outside here,
Yeah.
and then they'll say, right, you're going to be in Folkestone at this time, or you're going to be in Ashford at this time. And that's it. There's no links, no telephone numbers. I'm completely on my own, but at the same time being threatened. It had Romanian plates on the van.
El señor Cousins fue captado por varias cámaras en el centro de la ciudad, comprando algunas bolsas y poniendo gasolina en el coche. En un principio, afirmó que una banda de Europa del Este le presionaba para que secuestrara a la señora Everard porque necesitaba dinero. La señora Everard fue agredida sexualmente y murió estrangulada. Su cuerpo fue quemado y sus restos fueron arrojados a un estanque cerca de Ashford, Kent. El señor Cousins concedió la entrevista, esposado todo el tiempo. Inicialmente, negó cualquier implicación en este caso de desaparición. Sin embargo, la policía supo que fue la última persona con la que se encontró la señora Everard. El señor Cousins fue condenado a cadena perpetua por el juicio. Si crees que este fue el último policía que reaccionó a su cadena perpetua, entonces probablemente no has oído hablar del siguiente caso.
I've been told that I have PTSD, depression, but not that I am. No, I don't think that I have anything wrong with me at
Are you
this
currently
time.
receiving any treatment for any sort of mental disorder or condition?
Depression, anxiety.
Are you currently taking any medication for depression and anxiety?
Yes, I am.
Este es el ex-sheriff Todd Pate, de la oficina del sheriff del condado de Breckenridge. El 12 de marzo de 2020, el señor Pate estaba en el juicio para asistir a una audiencia de declaración de culpabilidad. Según los informes, el señor Pate estuvo involucrado en un accidente automovilístico en marzo de 2019 y había herido a otro conductor con el que chocó su vehículo. El señor Pate fue supuestamente encontrado ebrio después del accidente y fue arrestado y ahora se enfrenta al juicio. Fue acusado de 5 delitos graves y un segundo cargo de DUI. El señor Pate estaba allí en la audiencia para cambiar su declaración de no culpable a culpable. Hacer esto le habría permitido cumplir un menor tiempo en prisión, minimizándolo a varios días de un año. Para ello, tuvo que decir estas palabras al juez. Mira lo que está a punto de hacer.
My client, as the day approaches, is just apprehensive, and we had to talk through some things.
Are we ready to get on the record this time?
I think so. We still need to sign those other papers.
Okay, all right. And so let's get on the record first. All right. Mr. Pate, if you want to stand up there with your client, I'm sorry, with your attorney. We're on the record in 19 CR 44, Commonwealth of Kentucky versus Jerome T. Pate. We're here this afternoon. Initially, it was set as a pretrial conference that was continued from a January pretrial conference, the purpose of which was to further address pending motions, including motion to transfer venue, and also then to get this matter set for trial. The court has subsequently been advised that the attorneys have negotiated a resolution of this case on guilty plea. It is further my understanding that the terms of that plea have been fully discussed with, is that your phone, Mr. Pate?
Yes, it is.
You need to put it away.
Okay. I was just had
You
a...
need to put it away.
Okay.
Yeah. Has been fully discussed with the victims in this case, and that the terms have been, had previously been agreed to by Mr. Pate. At this time, Mr. Vowles, does it remain your client's intent to enter a guilty plea here today?
I think you better ask him that question.
Mr. Pate, if you'll raise your right hand to be sworn, please. Do you swear or affirm that the testimony you're about to give will be the truth, so help you God?
Yes, I do.
State your name, please.
Jerome Todd Pate.
And Mr. Pate, what is the last 4 digits of your Social Security number?
1120.
And what is your date of birth?
It's October 15th, 1969.
Have you ever been told that you suffer from any mental illness or condition that affects your ability to think or to reason?
I've been told that I have PTSD,
Are you
depression,
currently
but not that I am... No, I don't think that I have anything wrong with me at
Are you
this
currently
time.
receiving any treatment for any sort of mental disorder or condition?
Depression, anxiety.
Are you currently taking any medication for depression and anxiety?
Yes, I am.
All right, and have you taken that medication as prescribed?
Yes.
Are you under the influence of any other drugs or alcohol today?
No, ma'am.
Have you taken any over-the-counter medication that contains codeine, antihistamine, or any other substance that would affect your ability to think clearly?
No, ma'am.
At this time, is it your desire to change your plea from not guilty to guilty?
Do I have to answer that yes or no, or can I make somewhat of a statement? That's what I...
That is a yes or no answer, sir.
Will I have the opportunity to say anything further?
If it is your intention to change your plea from not guilty to guilty, then I will take your plea, and certainly you'll have an opportunity to make any statement that you want to make. But if it is not your intent to enter a guilty plea at this time, then I'm going to set your case for jury trial, and you're going to stop wasting my time and everybody else's time this afternoon.
Ma'am, I'm not trying to waste your time.
And then, is it your intention to enter a guilty plea at this time or not, sir?
No. Why am I wasting your time,
Mr.
ma'am?
Chambers, what is the Commonwealth's position at this time, sir?
Your Honor, we would move to revoke the defendant's bond at this time. We took part in a lengthy mediation. We agreed to continue this case 2 months to enter this plea today. I think we've inconvenienced the entire court system by canceling a pretrial date and continuing this matter for 2 months for him to resign from office. So we move to revoke his bond at this time.
Mr. Vowles, would you like some additional opportunity to meet with your client this afternoon before we proceed at this time?
You know, it's difficult for me to enter a guilty plea for a lot of reasons, and I don't want this court to think that I am trying to minimize, take away from, or deflect any responsibility that I had in this situation that occurred. I do absolutely feel like that because of my bad decisions, that this whole case took a turn that it wouldn't have taken had it not been the Breckinridge County Sheriff. It's difficult for me to plead guilty to felony charges where a prosecutor indicts me and immediately after getting an indictment recuses himself and basically testifies at the grand jury to facts that were not at all. And again, if I hadn't done what I did and drank and drove on March the 8th, I would not be sitting here, nor would anybody else. But I absolutely think I was indicted. That prosecutor said, got my indictment, I will jump out. Then I made an offer based on those indictments on a Monday. We sent an email back to Mr. Chambers' office to not accept, and 2 days later I'm indicted for assault first, one that if you're found guilty you spend 85% of. This was never an assault first case, should have never been an assault first case, but it became that, and it became that to push me in a direction to take a plea. I'm willing to take a plea, but I now understand how some people feel. I've defended the court system many, many times and still do, but I feel like I'm being very much bullied into doing something that's not right. Now, the gamble is big. If Mr. Chambers wants to go to trial and say, now let me tell you this, that, and the other, then I'm risking leaving my family, which I did that March 8th when I drank and drove. Thank God I didn't kill anybody. But I want this court to know, I want the people to know, and I want the public to know that Todd Pate holds himself responsible for everything that he did. But it's hard for me to lay down and plead to felony charges that don't apply.
La juez hace un receso al darse cuenta de que el señor Pate podría querer consultar a su abogado. Sin embargo, observa lo que sigue haciendo.
So I think we are back, Mr. Pate, and probably should have stayed in the place where we started. Again, I wanted to give you an opportunity to have further discussions with your attorney. But I think
I'm sorry, ma'am, for
no,
doing
you
this.
don't have.
I'm sorry for.
What I need to, I think we're back to where we were before. Is it your intention today to enter this guilty plea? And I think we're at a yes or no place at that point.
Let me say, can I say one more thing? I think everybody in this room wants this over with. And if I could address Blake, I hope you learn from this case I'm not mad at you. I'm not in any way upset with you.
Mr. Pate,
not that it
we
matters.
have reached that point now.
Okay.
This is either a yes or no. Are you going to enter your plea or not?
I guess everybody thinks it's funny.
Well, certainly not the people who I think are here with you today, Mr.
No, they don't. I've broken everybody's heart. But it's hard for me when I see Mr. Chambers sitting over there smiling. Let me just plea and get it over with for everybody. Plea to something that I absolutely do not feel good about, but I don't want you to try to send me to the penitentiary for years and years. If you can sleep with it, I can sleep with it.
Okay.
And this is probably
I think
unusual,
we're done.
but
At
let's
this
do
point in
it.
time, I think we're done. And so let me tell you where I think we are today, is that we have executed plea documents. Whether or not Mr. Pate has the right to withdraw his plea now that he's executed those plea documents remain to be seen. And at this juncture, this court could not, based on these preliminary statements that Mr. Pate has made, make a finding that this plea is knowingly, voluntarily, and intelligently made. Where I think we are today is that on the one hand, the Commonwealth can, if chooses to do so, to enforce the terms of this agreement based on the execution. Mr. Pate, I'm talking at this point in time.
Okay, I'm sorry. Sorry.
At this point in time, I'm going to sustain the Commonwealth's motion to revoke his bond. He's going to be taken into custody today. We will come back for further hearing as to whether or not to go forward with this plea or to set this case for trial. And I will look at additional conditions with respect to his bond at that time. He's going to be held without bond based on, at least at this juncture, there having been an executed plea where he was to serve 75 days with credit served.
El señor Pate se declaró culpable y aceptó la condena a la que tenía que hacer frente. Fue detenido por el juicio y llevado a la cárcel. Es triste saber que se condena a policías por los delitos que cometen a la sombra de la ley. Si te ha gustado este video, no dejes de darle a me gusta y suscribirte para ver más. Hasta luego.